Mr. Jaffe. All right, this is the, are you here on Van Maren versus Davidson?
Yes, Your Honor.
Or next.
Jasmine Davidson is my client, Your Honor.
Or next. What's that? So
Yes,
I see Miss Davidson's here. And do I see Edward Van Maren?
Present in the courtroom, Your Honor.
All right, Edward Van Maren is present in the courtroom. So I have a motion for, sir, if you want to come on up, you can have a seat at this table. Oh, actually, you're going to be at that table over there, okay? All right, so I have a motion up for summary disposition. I've reviewed the motion. I've reviewed all of the documents that were submitted to the court. And is there anything that I need to be aware of?
Yes, Your Honor.
Your Honor, excuse me.
One sec.
Excuse me.
One sec. Can I get your appearance, sir? Can you tell me your name?
Edward Van Maren.
Okay, you can have a seat. Mr. Jaffe, give me your name.
Your Honor, good morning. Attorney Brent Jaffe on behalf of Jasmine Davidson. Your Honor, if I could address the court with regards to the motion that I filed, Your Honor.
Okay, so it's his motion for summary disposition. So Mr. Jaffe's going to go first, and then I'm going to hear your response, okay? All right, go ahead, Mr. Jaffe.
Thank you, Your Honor. The motion was filed, properly served on this individual. Sorry, it was his poor decision to not retain a lawyer because he's not a lawyer and he has no idea what he's doing. That being said, he never filed a response, Your Honor. This is well over a month ago. And not only did he not file a response, Your Honor, but I just want to state for the record, and I have verification, but I don't need to get into it. This might be one of the most disrespectful people I've ever encountered in my entire life.
I don't want any personal attacks. Let's just get to the meat of the case. What is your motion based on? And just get to that. You guys don't have to like each other.
Failure to state a claim, Your Honor. This individual has never presented an iota of evidence to substantiate any claim that he's ever made, but rather this lawsuit was just an attempt for him to defame and harass my client. But again, Your Honor, no response. And respectfully, Your Honor, I would ask that this court hold this person to the same standard that an attorney would be held to. I would ask that my motion be granted accordingly, and this case be dismissed.
Sir, do you have a response?
Yes, Your Honor, I do. First and foremost, I was under the impression that defense never bothered to file an answer to this case to begin with. Moreover, as defense is trying to claim my attorney was never present during the said case, the previous custody case between defendant and myself, I have been.
So let me ask you this. Let me ask some questions. The parties were you married or dating?
Dating.
All right, so how long, when did you start dating?
We were together 5 years.
When did you start dating?
2018.
When did you split up?
22.
Okay, so you split up in 22. Your allegation is that this,
If I may, Your Honor, we started in 17, not 18. Our daughter was
Okay.
18.
Okay. So basically the allegation is that a bunch of these miniature charges were made. At the time, were you two lit these charges for like $3, $2, $1? I don't know if these are all like phone games.
That's exactly what it was.
Okay, it looks like phone games to me. So these were all charged, at the time the two of you were you living together?
Yes, Your Honor.
All right, so you were living together, you were cohabitating.
Yes,
Who
Your Honor.
was working?
I was.
Okay, and Miss Davidson, did you have an infant at that time?
Yes.
Okay, so there's a minor child. So is it a baby at this time or a young kid? I mean, there's no year on ISC like 1106, 1217, 320. It doesn't tell me the year these charges were made. Like, I can't tell from looking at the documents that were submitted when they were made. It just says year, or it says month and day.
That is fair, Your Honor, and I do have a stack of papers more than an inch thick of 4 years of bank records. I would be more than happy to bring.
This opening immediately sets the stage for an unusual courtroom battle. A self-represented plaintiff is suing his ex-girlfriend over what appear to be questionable claims, while the defense attorney wastes no time arguing that the case lacks evidence and should be dismissed outright. The judge quickly establishes control of the courtroom, shutting down personal attacks and focusing on the legal merits of the case. By the end of this segment, all eyes turn to plaintiff as he prepares to justify why this lawsuit should survive.
Were you guys living together at that
Yes, Your
time?
Honor.
Okay,
It
so,
also showed that she emptied my checking account while I was providing for both her and a minor child. One of those instances occurred while I was at a grocery store with a shopping cart full of stuff, and she still emptied my checking account.
all right, but there's no claim for that in here. I mean, I just see the claim is that I don't mean to call them micro transactions.
Exactly what they are.
But they're like $1.05, $1.05, $4.69, 91 cents, $1.05.
Several hundred in total.
These are, well, what is you made a claim for $6,500.
Yes,
What is-
Your Honor, and if I may also point out that during the custody agreement, when we were ordered by the court week on week off custody on a dozen separate occasions, I made verbal agreement, which I'll quote Pennzoil v. Texaco, and that verbal agreements are enforceable. I made a verbal agreement with defendant to take child on defendant's court-ordered scheduled week so that she could go out with friends in exchange for her to do the same on my week, and I was robbed of that a dozen times on my weeks. So for the sake of argument.
This is your guys' kid.
Yes.
I'm not a family law court. I mean, none of that is important to me. I have $6,500 of claim damages for a bunch of micro transactions that equal hundreds of dollars. And those transactions all occurred during the course of your cohabitation while you were the primary caregiver.
Yeah, Your Honor, that is correct, Your Honor. That is correct, Your Honor. And again, just to reemphasize that, again, not an iota of information or supporting documents or people with Texaco, whatever the legal scholar is quoting, has ever been presented to me, nor has this person ever contacted me. Again, he was rightfully served, Your Honor.
Well, it doesn't matter. I mean, if they're talking about making agreements outside of their parenting time order and one party's honoring them and the other party isn't, I am a district court judge.
The plaintiff begins explaining his side of the story, but the judge's questions reveal important details that completely reshape the case. The two parties were in a long-term relationship, lived together, and shared a young child. What initially sounded like a serious fraud matter starts looking more like a dispute arising from a failed relationship. As the plaintiff introduces bank records and claims his ex emptied his account, the courtroom begins questioning whether these accusations truly belong in civil court.
I do not do family law. I am not going to overstep my bounds and get involved in that. And certainly, I'm going to tell you my honest thoughts. I did family law for a long time. And if you two can't figure out how to get along on some level, you're going to screw your kid up. I'm just telling you, that's how it is. That's what I see here. And I see it all the time. And it's really disturbing to me because if you two talk poorly about each other, get mad at each other, in front of the child, can't communicate with each other, you are messing a kid up. You are. And I mean, and that's a family law matter. It's not in front of me, but
And Your Honor, I did represent.
I'm very sad to see it over and over and over again. Sir, do you have any other documentation that you want me to look at?
Your Honor, if I could actually go back to the motion in which defense made an effort to claim that my counsel never appeared.
Why do I care?
Because he's trying to have my case thrown out on multiple grounds that he's
Because you
presenting.
didn't file
No,
a
he's
response
saying,
to the
no. Listen, he is trying to get your case thrown out by saying there's no relief and there's no claim, that there's no legal basis for your claim.
So
Is that you failed to state a claim on which relief can be granted.
Rather than focusing on the actual financial claims, the plaintiff shifts toward complaints involving custody arrangements and verbal agreements about parenting responsibilities. He argues that promises were broken and that he was treated unfairly. However, the judge makes it clear that family court issues cannot simply be transformed into a civil lawsuit. As the defense points out the lack of supporting evidence, the plaintiff's argument begins losing direction and credibility.
So I keep asking you, what matters to me is what documentation do you have that she owes you $6,500?
Your Honor, would a couple write a contract for who's going to pick up children from school any given day of the week? No, most couples are not. So in the same sense, if a couple is together and one party owes the other money, are they going to write a contract?
Yeah, the answer is
No, and when one of the couples, so are you charging her for food she ate while she was the primary caregiver for your child and you were at work? Is she have to pay you back for the food she ate?
I'm asking
you a question, and guess what? I got the robe, sir. So I'm asking you a question. Does she owe you money for food, shelter, clothing that you paid for her while she was the primary caregiver for your child?
Your Honor, she does owe me for food, clothing, and shelter. During the 10-month span that I was under false pretenses, we were going to be a family.
In one of the most impactful moments of the hearing, the judge steps away from legal technicalities and addresses the bigger issue, the well-being of the child caught in the middle of this conflict. She warns both parents that ongoing hostility and poor communication can seriously affect their child's future. While emphasizing that family matters are outside her jurisdiction in this case, her remarks serve as a powerful reminder that personal disputes often carry consequences far beyond the courtroom.
Okay, so no. All right, listen. The request for relief in this case was the maximum that was allowed in district court in small claims. It's since been removed, but the amount claimed was $6,500, and the allegations were credit fraud, defrauding by means of solicitation of prostitution, possession of stolen property, promissory fraud, and emotional distress. Okay.
I do have several hundred hours of audio recordings held within my own home, as the Exhibit A submitted by the defense shows that the defendant was made aware that everything in my home was being recorded.
Your Honor, may I address the court briefly, Your Honor?
Very brief.
Thank you very much, Your Honor. As a practical matter, I represented my client also in the custody matter for over the period of almost a year, and respectfully, Your Honor, I'm not sure why this plaintiff feels he has a platform to do it, Your Honor. Again, there's no relief has been, nothing's been substantiated, Your Honor, and they actually took this serious, which I don't think he is. And again, I think it's a pure harassment technique, and he would have hired a lawyer, because that's why people pay a lot of money to go to law school.
All right.
The focus shifts back to the plaintiff's demand for $6,500 in damages. The judge repeatedly asked for documentation, showing why the defendant legally owes him that amount. Instead of presenting clear evidence, the plaintiff attempts to justify reimbursement for expenses incurred during their relationship. The questioning exposes a difference between emotional grievances and legally enforceable claims, placing significant pressure on the plaintiff's case.
I mean, listen, Mr. Jaffe, we don't have to get in the mud, though. Listen, as far as I'm concerned, I don't see any claim that relief could be granted on. I mean, all of these, when you have two people, and look at, I'm going to just use common sense and reason. When you have two people who are cohabitating with a minor child, an infant, or a very young child. What year was the child born in? 2018?
February 2018.
So we're talking about a kid who is not school age.
Correct.
Right?
She's 5 now.
She's 5 now. But all of these purchases, all of these, what I'm calling microtransactions, all occurred while the two of you were in a relationship. While she was the primary caregiver. And there are agreements that are made. I mean, you can look at it with common sense and reason, which is what I'm doing. And we're talking, look, she likes phone games a little too much. I'll give you that, but you can't come a year and some after the parties split up and claim $6,500 in an action because of transactions that occurred. She clearly had access to money. Did your client go to the grocery store, Mr. Jaffe?
Of course, for the family, of course.
At the time, no, Your Honor, she did not. She did not
Your
have
Honor,
a license.
absolutely. Again, Your Honor,
Yes. I have a court recorder. Do not make her suffer. She cannot type both of you at the same time. Okay, so you're telling me, Mr. Van Maren, that she did not ever have access to any bank account?
She had unlawful access to mine when she saved my credit information in her phone without my permission.
Okay, wait. So, the whole time you were together.
My grandfather took me shopping.
So she was never allowed to go to the store or make any purchases?
She went with me.
So she had no access to money. It's your statement. This is what you're telling me. She had no access to any money at all while she was staying home with this minor child.
She couldn't be trusted with money, obviously.
Okay, all right.
The courtroom hears the full list of accusations contained within the lawsuit, ranging from fraud claims allegations involving emotional distress. The plaintiff insists he possesses hundreds of hours of recordings to support his position, while the defense argues that the entire case is nothing more than an attempt to harass the defendant. At this point, the judge appears increasingly unconvinced that any of these allegations establish a valid legal basis for relief.
I find that there is absolutely the plaintiff has failed to state a claim on which relief can be granted. We're talking about microtransactions that occurred during the relationship between the parties where they resided together and had a minor child, and Ms. Davidson was the primary caregiver for said minor child.
Your Honor,
Obviously, sir. You have, if you want to file an appeal, sir, you are certainly entitled to that relief. That is my judgment. Mr. Jaffe, your motion's granted.
Judge Shackelford carefully analyzes the circumstances surrounding the disputed transactions, considering that the parties were cohabitating, raising a child together, and functioning as a family unit during the relevant period. She questions whether these purchases can realistically be separated from the realities of everyday domestic life. The plaintiff's explanations create further inconsistencies, strengthening the impression that the lawsuit lacks both legal and factual support. After reviewing the claims and hearing both sides, the judge reaches her conclusion. She determines that the plaintiff has failed to establish a legally recognizable claim upon which relief can be granted. The motion to dismiss is granted, effectively ending the case in the defendant's favor. Although the plaintiff is informed of his right to appeal, the courtroom outcome is clear. If you enjoyed this breakdown, don't forget to like the video, subscribe to the channel, turn on notifications, and we'll see you in the next video.